Good evening, everyone. I hope you can hear me. Welcome to this discussion about the latest case law on the legal obligation on a trust to bring a medical treatment case to court. My name's Vikram Sachdeva. I'm a silk at 39 Essex Chambers. Now, I've always been particularly interested in this area of the law, which has led me to obtaining both legal and medical qualifications. The structure of the evening is that we'll first have talks from our three speakers, and we will then seek to answer any questions which you can post throughout the talk on the Q&A function at the bottom. I see that some people have already used that function already. So do ask questions throughout. We'll seek to answer them at the end, and it should last around an hour in total, and the session is going to be recorded. We are very fortunate to have with us tonight the following. First of all, Arianna Kelly from 39 Essex Chambers. Arianna is apparently, according to legal directories, a superb advocate with star quality about her, I'm told. She has a public law practice with a focus in community care, mental capacity, serious medical treatment, mental health law and inquests. And Arianna will talk about the history of applications to court to authorize treatment or to authorize withdrawal of treatment from the inherent jurisdiction and the Bland case over 25 years ago to the MCA case law and the Vice President's guidance. Next up, we have Katie Scott. Now, I do enjoy embarrassing people at this point. The directories say Katie is a sharp and incisive legal brain and is also very personable at the same time. She advises and represents a broad range of clients in community care, mental health, and human rights claims, and specializes in welfare, medical treatment, and property and affairs disputes in both the Court of Protection and in the Family Division. And Katie will be talking about the very recent GUP case, which may or may not, depending on the view you take, have changed the law quite dramatically from what we thought it was before. Last and not least is Professor Stephen Playfor, who has been a consultant paediatric intensivist in Manchester since 2002, having trained in quite a few cities, Nottingham, Birmingham, Toronto, and Melbourne. And he's been clinical director for paediatric clinical care since 2019, and he's also a medical examiner for the Manchester Royal Infirmary. Now, Stephen has had more experience than any of us, it turns out, including following high-profile medical treatment cases, an expert Tafida Rakib, Pippa Knight, and Archie Battersby, and he's been in, I think, 7 cases from his own unit to do with medical treatment as well. And he will be talking about conflict and the paediatric intensivist. I will just quickly slip in a quick plug for a further webinar on Thursday, which is to do, Kieran, if you show us a slide, a university's duty to protect students' mental health. So if that subject interests you at all, you can apparently scan the QR code if you're quick and register. Otherwise, if you look on the Chamber's website, I'm sure it will be there somewhere. Right, okay, well, over to the talk now. And if I can, first of all, hand over to Arianna Kelly.
Thank you so much. Just get my slides up on the screen. Make sure those are coming out okay. And right, is that looking all right for folks? Good.
I think you need to start the slideshow.
My apologies. Sorry.
Yeah.
One button away. Sorry about that. Thank you very much. Good evening. So what I'll be talking about is a lot of the history leading up to the GUP case that we're going to be talking about today, and going back really to the 1990s and some of the really early cases around approving medical treatment in the court. These are pre-court of protection cases, and the first one looking at tonight is the Re F case, and this set out the court giving authorization for a sterilization operation for a patient who was not able to make that decision for herself. The general view at that point in time was that this was not required as a matter of legal necessity, but it was something that was very much seen as best practice. And the House of Lords looked specifically at a number of factors why they thought it was so important for such a declaration to be obtained in that case. Some of the factors that they really focused on were the fact that this was an irreversible procedure, that it had very significant consequences, and bore on what they termed in the case as the fundamental rights of a woman, in that case, as it was a sterilization, and also the moral and emotional considerations that went into it. It wasn't decided at that point in time that such an application was required, but there's a very strong inclination from that case that in that sort of very grave situation, that approval from the court should probably be sought. The case where a lot of this got ventilated to a much greater degree was in the Bland case, as Vikram had mentioned earlier. This was a case that was specifically looking at artificial nutrition and hydration, which is going to be a topic that we're going to be discussing quite a bit today. And I think it's much more on point for a lot of the issues that we're going to be raising. The first and probably most important point in the Bland case was the finding that artificial nutrition and hydration was treatment in itself. There was also the focus on the question of whether or not it was in the patient's best interest to continue to give that treatment. And they recontextualized this from the question of, is it in the patient's best interest to live or to die, but to continue to be treated in this particular way. At that point in time, it was the family division of the High Court, which the application was made to. And the view of the House of Lords at that point in time was that an application of this nature should be made in cases where there was going to be a decision to withdraw artificial nutrition and hydration. The official solicitor should be invited to act, and 2 medical opinions should be obtained. So really quite a bit of process and procedure around this, and very much a view that these are the sorts of cases that ought to be coming before the court. However, within Bland, and this is a thread that was picked up in the NHS Trust and Y case back in 2018, was a view that over time, there may come to grow a body of experience and practice that would build up which would obviate the need to bring an application in every case. Fast forwarding ahead here about 20 years to the case of AVS and an NHS Foundation trust. This is a very sad case of a man who had complex Creutzfeldt-Jakob disease. His brother had brought an application to the Court of Protection, which was then in its relatively early days, seeking a declaration that he should be given a certain sort of procedure to treat this Creutzfeldt-Jakob disease. However, there was no medical practitioner who was actually ready and willing to give that treatment to him at that point in time. The way that this was run before the court actually bears a lot of similarities with the case of N and ACCG, because the way that the Court of Appeal ultimately looked at it was more of an issue of case management rather than best interests. It took quite a robust line in the case in saying that his application was doomed to failure because there was no medical practitioner that was actually able to give him the treatment that could be sought. The Court of Appeal again took a very strong line in terms of saying that a declaration of this kind should not be sought because it would will not force the respondent hospital to provide treatment against its clinical judgment. To use a declaration of the court to twist the arm of some clinician as yet unidentified to carry out these procedures or put pressure upon the Secretary of State to provide I've just lost this. To provide a hospital where these procedures may be undertaken is an abusive process of the court and should not be tolerated. And the court concluded that if there are clinicians out there prepared to treat the patient, then the patient will be discharged into their care and there would be no need for court intervention. If there is no one available to undertake the necessary operation, the question of whether or not it would be in the patient's best interest for that to happen is wholly academic, and the process should be called to a halt here and now. So this case, I think, really crystallizes this idea about best interest on one hand and the idea of what the available options actually are on the other. Court of Appeal taking a really strong line that the Court of Protection is not there to make hypothetical decisions, and it would be inappropriate for courts to embark on best interest declarations for something that simply cannot happen for the person. The case of Aintree and James then goes on to complicate this even more. One of the points the court was making again here and echoing this is that a patient cannot demand that a doctor administer treatment which the doctor thinks is adverse to the patient's needs. However, the court opened this up a bit more broadly because one of the points that they made, and this has been something that's echoed both in medical treatment cases and more broadly in the Court of Protection, is the idea of best interest being viewed through the lens of the patient's point of view. To just read a quote from the case, the most that can be said is that in considering the best interests of a particular patient at the particular time, decision makers must look at his welfare in the widest sense, not just medical, but social and psychological. They must consider the nature of the medical treatment in question, what it involves, and its prospects of success. They must consider what the outcome of that treatment for the patient is likely to be. They must try to put themselves in the place of the individual patient and ask what his attitude to the treatment is or would likely to be. And they must consult others who are looking after him or interested in his welfare, in particular for their view of what his attitude would be. What the Supreme Court at this point is saying very clearly is this is not a reasonable patient test or a reasonable doctor's test. It's not that the patient's view must always prevail, but the whole idea of best interest is that it's viewed through the lens of the patient. So this changes the analysis to a certain degree from some of the cases that had come earlier. It's not just about medical best interest, but about the broader best interest at this point in time. One of the other really interesting points that was made in Aintree versus James is the idea of the futility of treatment. And Lady Hale opened this up to a greater extent of saying that futile treatment is that which is ineffective or of no benefit to the patient. However, a treatment can bring benefit even if it has no effect on the underlying disease or disability. So in cases around artificial nutrition and hydration, this opens it up to a greater degree in terms of looking at what would the patient have wanted if they were able to express a viewpoint at this point in time. Would they have wanted to stay alive in the manner that they're currently living in, even if there is no hope of recovery, or not? There are obviously some objective factors that get taken into the equation, but it becomes something of a hazier test. The outcome is less clear because it really does depend much more on this person and what they would have wanted if they were able to take the decision for themselves. N in a CCG brings us back to the thread of what a person can and can't choose and what the role of the court protection is in determining questions where options may or may not be available. And in a CCG, those who may not be familiar with the underlying facts of the case, this was a case about a young man with very, very severe physical disabilities. His parents wished for him to live in a care setting, but they also wished for him to come home and they would provide him with intimate care and they would look after him in the home. The CCG, which was funding his care, was not willing to fund the package of care in order for him to go home. They did not feel that it offered him any significant benefit and would have been extremely costly given the amount of care that would have needed to come with him, as well as the amount of equipment and other things that would have needed to be provided in the home setting in order to keep him safe. This was a case which ended up before the Supreme Court, and again, similar to the AVS case, was looked at primarily on the basis of case management in the Court of Protection. In the lower courts, there had been some consideration of the issue of whether or not the Court of Protection might step in and look at hypothetical questions where there was a real issue of a person's human rights that was on the line, and whether the Court of Protection should take a slightly more expansive and quasi-judicial review stance to these sorts of issues. However, in the Supreme Court, the answer to this was quite clear. The Court of Protection's power did not include quasi-judicial review powers, and they can only make the decisions that a person could make for themselves if they had capacity. The Court of Appeal in particular noted that the court has leeway to investigate, to prod, to challenge the decision-making of statutory bodies, but that doesn't actually follow that people need to hold a contested hearing on hypothetical issues which don't exist, and where in the court's word it would serve no useful purpose to do so. The court did note that this was not an issue of jurisdiction fundamentally, because had this option been available, the Court of Protection would have had jurisdiction to order it. But what it was, not fundamentally an issue of jurisdiction, but what it actually could order on the basis of the available options to the person at that point in time. And what the court found, the Supreme Court found in that case, was that in those circumstances, the court was entitled to conclude that in the exercise of its case management powers, no useful purpose would be served by continuing the hearing, and the judge was entitled to simply decline to hold any sort of contested proceedings on this issue. Around issues of serious medical treatment, again, there's been some lack of clarity over the years in terms of exactly what needs to come before the court. Practice Direction 90 had set out the definition of serious medical treatment, which in most cases around serious medical treatment, a lot of the obligations within the Mental Capacity Act are more around how decision-making should be undertaken and the right to an IMCA. Practice Direction 90 fleshes some of this out in terms of noting that certain matters should come before the court in the view as it stood at that point in time, and that include decisions about the proposed withholding or withdrawal of artificial nutrition and hydration from a person in a permanent vegetative state or minimally conscious state, as well as cases involving organ or bone marrow donation or non-therapeutic sterilization. This was picked up and I would say greatly limited by the case of NHS Trust and why. This was 2018 Supreme Court decision that both Vikram and Katie were involved in and can, I'm sure, elaborate on much further. But it was specifically about whether or not an application was needed to withdraw clinically assisted nutrition and hydration where there was no dispute around the person's best interests. The Supreme Court found that the situation had moved on since Bland, and artificial nutrition and hydration were now a well-established feature of medical practice. There was not a requirement under either the common law or the European Convention of Human Rights to bring these matters before the court, and artificial nutrition and hydration was not in a special category of life-sustaining treatment. There was a lot of discussion in the case as well about the need for scrutiny of diagnosis and whether or not the court's scrutiny and the involvement of the official solicitor was needed to prevent errors and mistakes of this manner. The court made two interesting findings on this. One was that the medical procedures and processes were now so well established that this risk had been very well managed outside of the court setting. But additionally, the Supreme Court found that diagnosis wasn't determinative of what was in a person's best interest. You had to look at the holistic situation that they were in terms of determining whether artificial nutrition and hydration continued to be in the person's best interest at that point in time. However, the backstop of all of this is if there was some lack of agreement between the parties, if some people in a family felt that artificial nutrition and hydration should continue and some felt that it should not, or disagreement between families and medical practitioners, or it was simply a finely balanced decision, then those were the sorts of applications that should be brought before the court. This was followed up relatively shortly thereafter, very early in 2020, with the Vice President's Serious Medical Treatment Guidance. The document did emphasize that it was guidance only, and it had anticipated that it would be superseded by the updated Mental Capacity Act Code of Practice, which still has not taken place, and no one ever knows when it will. But one of the things that was noted within this guidance is that just because medical treatment is serious does not mean a court protection application is required if there is agreement between capacity and best interest. So very much in keeping with the NHS Trust and Y case. However, this guidance does note specifically that consideration should be given, and it is highly probable that an application will be appropriate, again, if the decision is finely balanced or there's a difference of medical opinion, there's a lack of agreement on the proposed course of action, or potential conflict of interest. One of the points that's specifically highlighted in the guidance as well is that when any of the matters set out in those three items relate to the provision of life-sustaining treatment, an application to the Court of Protection must be made. And it's again stated within the guidance specifically that for the avoidance of doubt, this includes clinically assisted nutrition and hydration. I'd also note that, again, the Vice President's guidance is very clear that when deprivations of liberty are involved in serious medical treatment, that should involve an application to the Court of Protection to authorize the deprivation of liberty arising out of that. So drawing some of the points together in terms of the historical points before Katie goes on to GEP and how that's picked up many of these threads, applications have proceeded in two formats. Some of these have been brought before the Court of Protection for declarations on best interest. What's interesting from some of the case law is that applications have been brought before the Court of Protection in cases both where people have been willing to offer this treatment and where they have not. However, ACCG and the AVS case both set out pretty clear precedents that the Court of Protection, in using its case management powers, should have a pretty clear eye on what is and is not available. That's not necessarily a question of jurisdiction, but it is a question of whether it's appropriate for the court to be making declarations on things that are not in practice available and could not be given to the person if they were found to be in their best interest or had been ordered to do so. Another thread on this is around when an application is needed to the High Court or Court of Protection in relation to the withdrawal of artificial nutrition and hydration. There has been a lot of back and forth around that, and with this touchstones of it being the Bland case and the NHS Trust and Y case, both of them looking at the initial position, which was you would always need an application of this kind, and why narrowing it down and putting it in the category much more akin to other forms of serious medical treatment. And with that, I will hand back to Vikram.
Thank you very much, Arianna. A very interesting overview of the history. now to the latest case, which is the reason for this webinar. Over to you, Katie.
Thank you very much. I am trying to share my screen. Great. Okay. Give me a moment. Here we go. I think that. Fantastic. Okay. So I'm going to talk about the GUP case decided by Mr Justice Hayden earlier this year. So what actually happened in that case? Well, it was a case about EUP, who was a woman in her 80s with a history of strokes. She'd undergone stenting of the left internal carotid artery, and she'd had a poor neurological recovery, including further strokes. She'd had a period in ICU in which an NG tube had been inserted, and she'd been discharged with that tube in place to the stroke ward. And the tube then became displaced and was removed. And there went then extensive efforts over a period of 7 days to re-site another tube, and that proved impossible. Now, the trust came to the view, and this was accepted, this was accepted by the court, that there was no safe and reliable feeding route that could be secured for EUP. And so they took the view that they tried the NG tube, that hadn't worked. They took the view they couldn't provide her with a gastrostomy, and the TPN was not a goer either. So they, unsurprisingly, were not able to offer EUP, clinically assisted nutrition. They did perhaps rather oddly, provide her with clinically assisted, IV hydration. And I don't want to get distracted by that issue, but the court had something to say about that in the judgment, and you can read that if that's of interest. So the trust weren't able to offer clinically assisted nutrition, and so they instituted a palliative care plan, which did not include feeding. And the family didn't agree with this and wanted them, well, it's not clear from the judgment precisely what the family wanted them to do, but that there was I think it's right to understand there was a disagreement between the trust and the family about this issue. Now, the trust, perhaps unsurprisingly, given what Arianna's just told us about AVS and about N and ACCG, didn't bring the matter before the Court of Protection because there wasn't an available option of clinically assisted nutrition for the court to choose on EUP's behalf, having undertaken a best interests evaluation. But nevertheless, the court undertook a full merits, sort of full best interests evaluation of this hypothetical or academic treatment, and concluded that since insertion of the stent, EUP had little or no interaction with her environment, unable to verbally communicate her wishes, the extent of her brain damage, and the broad neurological clinical picture provides no foundation for any hope that she will survive or recover in any meaningful way, which was what, of course, the family were hoping for. And the court therefore held on the merits that it was not in EUP's best interest to be provided with either nutrition or hydration. So what is interesting and potentially troubling about this judgment is what the court said about the process, because the court was critical of the trust for failing to bring the application themselves before the court. The application came before the court as a result of EUP as a litigant in person becoming the applicant. And so the court had this to say at paragraph 48 about that decision that the trust took not to bring the matter before the court. The likely reasoning behind this is that the trust considered that there was no ethical route to provide nutrition to EUP, and that was, of course, accepted by the court. The family disagreed and saw this as passivity with profound consequences. They perceived an important decision having been taken, even though the decision was to take no action. They considered that the court ought to be able to review that decision-making process and identify its own evaluation of where EUP's best interests lay. I agree with the family A decision not to provide nutrition is every bit as serious as a decision to withdraw nutrition. Where there is conflict, these cases must be resolved by the court. So the court's there saying that there are two reasons why the trust was wrong not to bring the matter before the court. Firstly, because the court ought to be able to review the decision-making process of the trust, and the decision-making that the court must be talking about there is the clinical decision not to offer the treatment, the nutrition, to EUP. That must be the decision that the court is there wanting to review. And secondly, because the court should, in Mr Justice Hayden's view, be able to carry out its own evaluation of where EUP's best interests lay. And then if we go on to look at paragraph 50, we can see there the importance that the court placed on the fact that there was a disagreement between the family and the trust. So where there is conflict in these serious medical treatment cases, it's in everybody's best interest, but most importantly, P's, to bring an application to court that will be most efficiently achieved if it's driven by the trust's application. And there are many and obvious reasons why it's also to the trust's advantage to have their treatment plans in cases such as this scrutinised by the court. So this judgment does seem to suggest that where a trust has made a lawful, because it hasn't been challenged, clinical decision, that is a public law decision, not to offer a particular treatment to a patient because it's not clinically appropriate or not clinically indicated, or in fact, in this case, not even clinically available, that there is still an obligation where there's a dispute about that, where there's a dispute about whether or not the treatment should be provided, there is an obligation on the trust to bring that dispute before the Court of Protection for review and to allow the court to carry out a best interest analysis. Now, there are a number of difficulties with that. First of all, just dealing with the question of review, it's of course not for the Court of Protection to review public law decision making. So given that the decision in question is a public law decision, of course, the place where the patient or indeed the patient's family, in EUP's case, could have challenged that decision not to offer the treatment is, of course, in the administrative court by way of judicial review. So that, I think, is the answer to the first point that the judge raised in paragraph 48, the review of the clinical decision making. The second relates to the question of allowing the court to carry out its own best interests analysis. And the court was there very, was persuaded by the argument put before it that there was an obligation on the trust to bring an application as a result of the 2020 guidance issued by Mr Justice Hayden when he was Vice President. And the court looked at paragraphs 8 and 9 of that guidance, and Arianna has set that out. But in short, what it says is that if there's a lack of agreement about a course of action, then it's highly probable that an application to the Court of Protection should be brought. And paragraph 9 makes it clear that where that is in relation to provision of life-sustaining treatment, then ECHR human rights jurisprudence means that an application to the Court of Protection must be brought. But the problem with relying on that guidance in this case is that it ignores the fact that the guidance is referring to disputes about what is in a patient's best interests, and it is not referring to disputes about clinical appropriateness. So if we go back to the case of Burke from 2005, we can see the stages in which clinical decision-making actually should occur. So the first stage is that the doctor, exercising his professional clinical judgment, decides what treatment options are clinically indicated, i.e. will provide overall clinical benefit for his patient. And he then only offers those treatment options to the patient that are clinically indicated, or sometimes it's called clinically appropriate. And that stage of clinical decision making is a public law decision, as I've said, reviewable in the administrative court by way of judicial review. Once more than one treatment is offered, the risks and benefits are identified to the patient can then choose between those treatment options. And in the case of a patient without capacity, a decision is made about which of those treatment options, if any, is in the patient's best interests. And it's at that stage, of course, that the Court of Protection has jurisdiction and can choose or consent to or refuse treatment options on behalf of a particular patient. So the problem with, as I see it, the decision of GUP is that the court has failed to understand. The decision made by the trust was at stage one, which is an administrative decision, a public law decision, but it was treated by the Court of Protection, by the judge, as if it was a best interests decision. And this slide just makes the point that the fact that GUP, EUP's son, disagreed with the decision of the trust not to offer nutrition does not turn the decision into a best interest decision, and nor does the fact that the patient lacks capacity to consent or refuse treatment. And it seems to me that this approach that Mr Justice Hayden took is in direct contradiction to the approach taken by AVS and N, as articulated by Arianna, because what the court engaged in was a best interest analysis of a hypothetical or academic treatment, because the trust was not had not offered EUP the clinically assisted nutrition. So it seems to me, to that extent, that the court was wrong to come to the view that it did. So the question then it can be asked, well, is there anywhere else in, for example, human rights jurisprudence that we can look to see whether or not there is an obligation on a trust in the circumstances pertaining to EUP that would require them to bring an application to the Court of Protection to review its decision making in light of where it's made a decision either to withdraw or not to offer life-sustaining treatment. Now, I just want to make it clear that that Mr Justice Hayden did not look at the ECHR, and so this is going beyond the terms of the judgment. But it seems to me that the Article 2 does not require such an application to be made. And I say that because even if one could find within Article 2 an obligation for an application to be brought before a court in such circumstances, it certainly wouldn't be before the Court of Protection. It would be by way of judicial review. But I don't say that Article 2 goes that far in any event. But there is, of course, available to a patient or to a patient's litigation friend a review of clinical public law decision making about offering treatments to a patient by way of judicial review. And just thinking that through, would in any event such an obligation be workable? It would mean that every decision made by a clinical body to withhold life-sustaining treatment would need to be brought before a court. So, for example, a clinical body that decides not to provide a patient with cancer with a cancer drug on the basis that the patient doesn't meet the cost-benefit criteria, that would have to come before the court. How about a clinician who decides, following NICE guidance, not to provide a dementia patient with clinically assisted nutrition and hydration, and that is not agreed by the family? Again, that would require that decision to be brought before the court. And how about a clinician who decides not to admit a person to ICU because it would serve no clinical purpose, and that was disputed by a family? It seems to me that there is that those kinds of on the analysis of GUP, those kinds of decisions would have to be brought to the court. So where are we now? So I pose the question, which I've already answered. Is there an obligation on a trust to bring a case before the Court of Protection for a best interest evaluation where there is only one clinically indicated treatment option because there is a dispute about this with the family? And I think it's clear from what I've already said that the answer to that, in my view, is no. But I do just leave you with these thoughts. It is not always easy to distinguish between a dispute about clinical appropriateness, including a dispute about whether a treatment is futile, and a dispute about whether a treatment is in principle appropriate, i.e. will be offered to the patient, but is nonetheless not in the person's best interest. And that, I think, is where that really needs to be bottomed out by trusts and by clinicians at an early stage, so that can inform the approach that is taken to any kind of dispute with the family. Secondly, if there is a clinical view that a treatment is not clinically appropriate, as was taken in GUP, it's always sensible to obtain a second opinion about that, because that may inform decision making and will help concentrate the minds and focus on the issues. And there is always the option for a trust who is getting nervous or about what they are doing to bring proceedings for a declaratory relief about the lawfulness of the treatment that they are providing or indeed not providing in the KBD. So with just drawing your attention to the article on this by Alex and Tor, I'll now pass over to Steve.
Thank you. So my name is Steve and I'm a paediatric intensivist in Manchester. I should make clear that the views I'll be expressing are my own and not those of my employer. I'm very grateful to be able to contribute to this discussion and raise some points, some of which might be new to you. So in paediatric critical care, we experience conflict every day at some level, but the most damaging and expensive conflicts we come involved in are where we have to seek a judgment to discontinue life-supporting therapy when we've been unable to reach a consensus with families. And these cases are becoming more frequent. I think most of the country probably is aware of these high-profile cases that you see reflected here with Alfie Evans and Charlie Gard. So you might very sensibly ask why these cases are getting more common. And it reflects the population of patients that we look after in paediatric critical care these days. This is a paper from my colleagues in Newcastle that was published nearly 10 years ago, which reflects the fact that paediatric critical care has evolved from a specialty that previously dealt with acute illness in mostly previously well patients to just one part of the multidisciplinary team that now looks after children with complex chronic illness. And that in turn reflects the population that we serve. If you look at the prevalence of children living with life-limiting conditions in the community, you can see that there's been a really significant increase over the last 20 years or so. And these are mostly congenital problems that we see the increase in. And this doesn't primarily reflect any development or change in medical technology, but more that the provision of life-supporting therapies are being extended into groups where previously that would not have been felt to be in the child's best interests. And an example of that might be children with trisomy 18 or Edwards syndrome, who you will now find being treated in UK paediatric critical care units. And this situation is extended so that today And on any given day, probably 60 to 80% of the care being delivered in each UK PICU will be considered to be at best inappropriate by the multidisciplinary team looking after those patients. And this pattern of life-limiting conditions in the community is predicted to increase certainly through till 2030. So the problem is not going to go away quickly. And much as we enjoy meeting and working with our colleagues in the legal profession, there are very significant harms and costs associated with these cases, particularly the highest profile, longest lasting cases that we get involved in. And that impacts on every element of the healthcare system. In terms of the healthcare organizations themselves, the primary harms are that of cost, the use of resources, and the potential for reputational harm. So just as a broad example of that, over the 10 years leading up to 2023, we saw judgments on 6 patients from our own paediatric critical care unit seeking to discontinue life-supporting therapy. And that cost the trust in the region of £1 million in legal costs. But given that a day in a PICU is costed around £2,500, that equates to a bed occupancy cost of nearly £8 million. Or to look at it another way, in terms of the duration that these patients stay in hospital, the 6 patients described here would be equivalent to a patient being in a bed every day for 9 years. And you have to reflect that at the end of those 6 cases, we were granted permission to withdraw life-supporting therapy. Another way of looking at that duration of stay, given our median length of stay for our patients is quite short, we could have looked after another 938 patients if it hadn't been for these 6 patients. In terms of healthcare professionals themselves, there's been quite a lot of work done over the last few years looking at the personal impact of burnout, of the reduction in function of teams, negative impact on performance, the impact on an individual's well-being, and the description of moral distress. And that's become increasingly well recognised, particularly amongst nursing staff who spend a considerable period at the patient's bedside. For medical staff, one of the particular costs is that of time. And for the cases that you're involved in personally, that involves statement writing, briefing legal teams and appearing at hearings. But for each of those cases, there'll be 2 or sometimes 3 PICU or other clinical expert consultants who are brought in from around the country to provide second opinions. And at the moment, that is a really poorly regulated ad hoc experience, providing a second opinion. Consultants aren't trained for that. We certainly aren't remunerated for it in the huge number of cases. Occasionally, you might be formally instructed to provide an opinion for a court, but most commonly, you're driving halfway across the country to assess a patient as a favour, effectively. And as an example of that, just a few weeks ago, I was asked to support colleagues in Birmingham and was given a time limit of 36 hours to go through a whole patient's medical record, go and examine them and produce a report for the court. We see considerable impact on patients and their families. There's an increased risk of healthcare errors associated with conflict. We see poor therapeutic relationships develop. Children have a worse prognosis in those situations. And we see families as a whole suffer. We see parents losing their jobs. We see relationships break up. And we see real harm for siblings. This is largely unresearched, but you see considerable damage done to the lives of siblings who spend less time in school and, I believe, achieve less. In terms of useful changes to the system, so you will be familiar with the Nuffield Council of Bioethics Independent Review, which came out in around September last year, looking at disagreements in the care of critically ill children. And they came out with a number of recommendations, a few of which I've put up here. It was interesting to see that, in keeping with previous research, that a breakdown of communication was one of the most significant contributors to conflict. It was also clear again here how the serious disagreements are less common, but take up a huge amount of time and resources when they do occur. And in terms of interventions that are found to be helpful, they've mentioned second opinions as being potentially very useful. They do talk about mediation, and they reflect that those who participated in the work reported that mediation had been less helpful. But I would stress that the participants in their work hadn't really been given the opportunity to see mediation in action in a way that is likely to achieve results. And at the current time, mediation is generally brought in at a pretty late stage in the development of conflict, by the time that parties are entrenched in their positions and unable to compromise. That would just be a personal reflection on the possibility of the effectiveness of mediation in these circumstances. What else is new? Well, in May of last year, NHS England published an e-platform to improve the management of conflict between families and healthcare professionals. This was developed collaboratively with the families of children involved, with healthcare professionals and experts, with the Royal College, and with other charities involved in this field. And as part of that, the NHS England appointed 7 regional conflict management champions for an initial trial period that ends at the end of March this year. Hopefully it's going to roll on forwards. But the website contains a lot of very useful resources. The key to it are a series of 3 e-learning modules, which are free to access for NHS professionals. You just need an e-learning for health account to access those. But along with that, there are resources for families. There are resources for organisations in terms of the governance aspects of managing conflict, and also for the well-being of staff involved. And this platform has been endorsed and approved by most of the important organisations on the medical and clinical side in the country. The 7 regional champions come from a variety of backgrounds. Myself and Kurum are paediatric intensivists. You have Sally here, who's a paediatric nephrologist who works in Birmingham. Rennie McCulloch, some of you may know, is a hugely experienced palliative care consultant at Great Ormond Street. And so we've been rolling out the training and signposting families and professionals to the website and the e-learning package in our regions. And if we just prevent one of those high-level significant cases going all the way to court, then you can see how valuable that would be for the whole healthcare system. So what would be on my personal wish list in terms of improving conflict? So I would really like to see a properly structured and funded evaluation of really early independent medical mediation. I think as clinicians, we can recognise which cases are going to run and end in a lack of consensus, and even identify those who we're going to be seeking judgments on withdrawing life-supporting therapies very early, within the first few weeks of critical care admission. And it would be great to see a proper trial of mediation come in those early stages where both parties have something that they can compromise on. It would be good to see some sort of non-adversarial, or at least less adversarial forum for the resolution of disagreements between clinicians and families. And the Nuffield document suggests using some different legal models that might be less adversarial in coming to conclusions in these cases. For us clinicians and for the Royal Colleges and societies, it would be good to put together a structured national system for obtaining second opinions, so that it can be properly trained for and remunerated and fit into our job plans. It should be recognised that at the current time, the majority of cases, and the ones that I've mentioned here, have involved children who've become stuck in a paediatric critical care unit because of their reliance on certain types of life-supporting therapy. And those children who either don't come to PICU or just come occasionally and for short periods can still be experiencing considerable personal burdens. And those really aren't being addressed at the current time. And lastly, just another factor which has become a significant personal concern for me is clarifying the status of children who don't have the standard balance of burden and benefit that we have to consider during these proceedings. Because of that change in population, we're now seeing more children who are essentially unresponsive and who don't experience suffering or discomfort, but similarly have no demonstrable interaction with the environment and the people around them. And in those situations, there's no particular medical expertise or judgment that's being required. Very often the facts are agreed, and the question is more of a societal issue of the status and the value of those children. So that's everything that I wanted to cover. Thank you very much for your attention.
Thank you very much, Stephen, for that. We've been asked a number of questions and we'll seek to answer some of them, and the others we'll answer electronically if we may. I think one of the main questions that has arisen is, what are trusts now to do then, where they're being told by us and possibly other people that if an option isn't an available option, it's not appropriate to apply to the Court of Protection to decide between an available option and an unavailable option, because the Court of Protection is there to provide statutory consent for a particular treatment as opposed to another one. And if there's only one available treatment, then the decision is quite a narrow one. And if there are no available treatments, then what to do? So faced with this case from the former Vice President, what is a trust to do where legal advice might be, well, technically you don't need to apply, but there's a case that says you do, or to be more precise, where a trust has been criticised for not taking the point to court because nutrition wasn't an available option in this case. It was impossible to get the NG tube in. So what was the point in asking the court whether it was in the patient's best interest to have nutrition? What does the panel think about what people should do now, pending further guidance from the court? And I should say, I don't know the answer to that either. Anyway, I'd be interested to see what your views are.
I think just
Well, go on, Arianna, you go. No, you go.
I'll say something, then Katie will say something more intelligent. We'll take it that way. But I mean, I think one of the things that I think comes out, not necessarily just with the GU case, but I think sometimes in the way that these cases are formatted before the court, and certainly some of that I've been involved in, is you get to a point where the clinicians on the ground feel that what is happening is unethical, but in reality, what they feel is unethical is the status quo. And I think there is often a question in that case if people are saying, well, this shouldn't be an available option, but actually is it? You know, would the trust actually feel confident in itself saying, we are no longer willing to continue offering it? Or would they say, well, if we were ordered by the Court of Protection to do it, we would in fact offer it, at which point it is then an available option and into the COP and into the COP realm. But I think the question, Vikram, you're getting at is, you know, should trust have this confidence if they do truly feel that they're doing something unethical to simply stop without making that application? And this is where I'll hand back to Katie to say something, as I say, more intelligent on that point.
No, I mean, I'm not going to say anything more intelligent, but I just think that the decision was wrong. I think on that point, I think one of the things that's slightly muddied the waters in that decision of GUP is that there was the EUP was being provided with artificial hydration, and the court made a decision that it was not in her best interest for that to continue. So there was a best interest decision to be made by the court, although interestingly, there wasn't, as I read the judgment, and I may be wrong about this, a dispute about that when it went before the court, because the clinicians had provided it and the family wanted it. So I'm not sure that was the reason for the dispute, and it was before the court. But I think because I think the decision is wrong, I don't think that it should be followed. I don't think it's consistent with higher authority, and it's unlikely there's going to be any further guidance arising from that case. It's not going to be appealed because there's no it's not going to be appealed, and so I think we're stuck with it, and we've just got to learn to live with it. So if people are very nervous about it, what they can do is bring an application in the King's Bench Division for declaratory relief about what they're doing, and try and get some comment on whether or not it was correctly decided. But otherwise, I think you've got to do what you think, what your legal advisors are telling you, and if they're telling you that it's wrongly decided, I don't think you should be going to the Court of Protection.
I mean, to be fair, there was still an available option for life-sustaining treatment, and the question of whether hydration should still be provided was, in theory, a live issue, because the Trust was providing it, but it was clear that they thought the palliative path was the right path. And I think that in other cases, not necessarily this one, where a Trust is providing a particular type of treatment, let's say renal replacement therapy, but because, say, the blood pressure has been dropping calamitously during the renal replacement therapy, they want to stop it, and they're reaching the point of not wanting to provide it anymore, then that does raise the question of whether it's truly something they really don't want to provide, but they will if ordered, or that they won't provide it. And I think Alex and Tor also commented in their article that Aintree and James, which I remember acting for the Trust in, was really a case where the Trust didn't want to provide it as an available option, these various things. But again, there's some ambiguity, because if you have been providing a particular treatment, let's say resuscitation or inotropes or something like that, it is quite hard to just turn from that into we're simply not going to provide it without a court saying that that's lawful. So I can see where these difficulties arise, but I also think that it is hard to see how, where nutrition wasn't an available option, how that could be something the court could rule on in terms of best interests. Another question that has arisen is whether there is this judgment might affect other disputes on best interests, for instance, do not resuscitate orders, and whether they're clinically futile. Presumably, there is some relevance to those cases, depending on whether they're truly not an available option or whether it's a best interest dispute. Don't know what the panel thinks about that. It's not just a case about CANH, is it? If it's right.
Yeah, I would agree that it's not just a case about CANH. I would agree. I mean, Although the judge, yes, I mean, I think it's about any life-sustaining treatment, which could include DNA, CPRs, and various other treatments.
Or could even be all treatment. I don't think it's necessarily restricted to life-sustaining treatment, because there is criticism of trusts for not making applications quick enough. So another way of looking at it might be for trusts to work out what the available options are, to work out early on if there's a dispute in best interests, and then to apply to court if there is. But Stephen, I don't know what you think about this approach of whether a trust should apply quickly to court where a dispute arises, or whether a trust should actually spend some time trying to talk to the family and possibly trying to mediate before rushing to court.
I mean, my area of expertise is pretty narrow in terms of paediatric critical care, but at the current time, the balance of effort is 95% on the side of trying to build a consensus and a functional relationship with the family, and try to come to some agreement using the various tools that are available to us.
Yes, so in a way, there might be a tension between applying to court quickly when a dispute arises and then spending valuable clinical resource time speaking to the family and trying to explore what they're thinking and seeing if there's a way of compromising. If you had to immediately down tools and draft witness statements, court, then it is a different focus, isn't it?
That's absolutely right. And it's inevitable that relationships become worse and less workable with families once you embark on any part of a medico-legal process with families. I mean, to the extent that locally and in other units around the UK, we've had a dual lead system in those circumstances. So we have one consultant who purely deals with the clinical aspects of the case and is able to maintain a working relationship with the family, to leave somebody else to deal with the medico-legal side.
We've heard, thank you, Stephen, for that. There's another question that's been asked, which is, if it's not an available option in one trust, what's the guidance about whether families can look for that option elsewhere, either another trust in this country or overseas? And do trusts need the Court of Protection to decide in that case it's not in P's best interests? Does anyone have any views on the ability of the family to look for other trusts? Certainly I don't know, Arianna, do you have any views on that?
I think it's just, I mean, looking to AVS and a CCG, I mean, if this actually exists, then there is a live option for the Court of Protection to potentially choose. I mean, and I think that has come up in some of the high profile cases where things have been put forward in other countries. The extent to which those were feasible, I think, was often very much in question. I think, as it was actually in the AVS case, where it was being suggested by the brother that this theoretically could happen, but actually when it was investigated by the court, it didn't actually seem as possible as that. So I mean, I think that is a fundamentally different situation, because it does put it back into the realm of the cop. But I think often the processes around second opinions and what's being done will clarify the extent to which this is something feasible, or how much whether or not it is likely to be in the person's best interest.
Yes, but certainly in when one acts for families, one does look for other places that can provide treatment. In to feed Re GUP, we managed to locate treatment abroad in Italy that the court saw as an available option, saw that it was realistic, that it was the funding was in place, and that's why the court did rule on best interests in relation to available options. So that's certainly something that arises in the cases. It is certainly an issue, I think, that will keep raising its head. So another question we've been asked is to do with the influence of second opinions. There's a new law, isn't there, Martha's Law, coming in to do with a right to a second opinion, and that hadn't, according to the Burke case, been a legal right up to now. It was simply a matter of good practice. Does the panel think that the obtaining of second opinions might change a trust's view as to what should be an available option? Is that possible, Stephen?
I mean, to the extent that we've seen what Martha's Law is likely to include, it's I think it's much more about the acute clinical assessment of the patient involved, and it's to really cement the ability of both ward-based clinical teams, but also the families, parents and carers to obtain an urgent review by another clinical team, and that's almost always going to be a critical care outreach team of some sort. And I can't see that would extend to the longer term issues of formal second opinions. And as somebody asked in the questions about mediation, that's much more about an acute life-saving review by a team, which it's going to happen immediately or almost.
But how often,
I mean,
sorry, Katie, do go on.
Well, I was going to say, certainly I've had cases where the second opinion has come in effect from a independent court expert, and they have come to a different view to the clinical team, and the clinical team have then changed their mind and offered the treatment. So I think it can happen. Yes,
that's my view too. It doesn't happen very often, but it can certainly happen, and that can be a very worthwhile thing for trusts to do, even before they apply to court, actually, because sometimes a sense check from someone outside your own circle can be very useful. Final question, I think, and it's about the use of information in social media that may not be accurate, where it's used to raise funds. Is that sort of information likely to make the situation worse, both in court and outside court? Does anyone have any experience of that? Certainly, one sees some ambitious claims by parties to proceedings and people who aren't parties to proceedings, which may or may not be based on same solid science that some of the other evidence in the case is based on. But on the other hand, I suppose the contrary view is, if it's a ostensibly competent medical practitioner with the right speciality, and if they are expressing a view, whether they've seen the patient or not, that something can be done, shouldn't a debate be had? Because I think it is important to consider all of the possibilities in these most important cases, and sometimes an external view, as I've said before, can be very valuable in changing people's opinions. Right, well, we have run over by about 10 minutes our 1 hour slot. So it simply remains for me to thank very much the speakers for their excellent presentations, and to thank you for your time this evening. Good evening, everyone.